Pacta Sunt Servanda is a fundamental principle in both international law and contract law, meaning agreements must be kept, or contracts must be honored. This principle asserts that once parties have entered into a binding agreement, they are obligated to fulfill their contractual commitments in good faith. Origin and legal basis. Latin term. The phrase Pacta Sunt Servanda originates from Latin. Historical context. Rooted in Roman law, the principle has evolved and been incorporated into various legal systems and international treaties over centuries. International law, enshrined in Article 26 of the Vienna Convention on the Law of Treaties, 1969, which states, "Every treaty in force is binding upon the parties to it, and must be performed by them in good faith." Application in international law. 1. Treaties and agreements, binding nature. In international law, treaties and agreements between states are considered legally binding under the principle of Pacta Sunt Servanda. Performance in good faith. States are required to perform their treaty obligations honestly and fairly, without resorting to deceit or evasion. 2. International organizations, charters, and conventions. International organizations, such as the United Nations, are governed by charters and conventions that member states are obligated to respect and fulfill. Accountability. Member states can be held accountable for non-compliance with international agreements. Application in contract law. 1. Private contracts. Enforceability. In private contract law, the principle ensures that contracts are enforceable and that parties are held to their promises. Good faith. Requires parties to act in good faith and honor the terms and conditions of their agreements. 2. Commercial transactions. Reliability and trust. Fosters reliability and trust in commercial transactions, encouraging parties to enter into contracts with confidence that they will be honored. Legal recourse. Provides a basis for legal recourse in cases of breach of contract, ensuring that aggrieved parties can seek remedies such as damages or specific performance. Exceptions and limitations. While Pacta Sunt Servanda is a fundamental principle, there are exceptions and limitations, particularly in international law. 1. Rebus sic stantibus. Fundamental change of circumstances. Definition. A principle that allows for the termination or modification of a treaty if fundamental circumstances have changed unexpectedly and radically. Application. Applied cautiously to avoid undermining the stability of treaties and contracts. 2. Coercion or fraud. Invalid agreements. Agreements entered into under coercion, duress, or fraud may be considered void and unenforceable. Legal protection. Protects parties from being bound by agreements obtained through unethical or illegal means. 3. Public policy and illegality. Contrary to public policy. Contracts or treaty provisions that are contrary to public policy or illegal in nature may not be enforceable. Judicial review. Courts and tribunals have the authority to review and invalidate such agreements. Importance and significance. 1. Stability and predictability. Legal certainty. Ensures stability and predictability in legal relations, allowing parties to plan and conduct their affairs with confidence. International order. Upholds the international legal order, promoting cooperation and compliance among states. 2. Trust and confidence commercial. Trust. Builds trust and confidence in commercial and contractual relations, fostering economic growth and development. Diplomatic relations. Strengthens diplomatic relations by ensuring that states honor their commitments. 3. Reciprocity and mutual benefit. Mutual obligations. Recognizes the reciprocal nature of treaties and contracts, where parties benefit from mutual commitments and obligations. Fairness. Promotes fairness by ensuring that parties live up to their promises and expectations.